Okay, all right, thanks. My name is Nathan Moses. I'm with the Division of Water Rights, obviously. Work in the Southwest region. I'm the regional engineer down there. When I was in college, this doesn't sound right. Is that better? Okay. I had extensive education in water rights. It was in my water resources management class, and we got to about page 367, and my teacher said, there's these things in Utah called water rights, and we administer them by priority. And then we went back on to Darcy's Law, and so that was the extent of my education for my career. So I'm glad we have trainings like this that give us a more detailed look at what water rights really mean here in Utah. Let's see if we got this. Okay. So where we'll begin is with a history of water rights and a history of water rights as they apply to Utah. In the eastern United States, they use a law called Riparian law for their doctrine and as to how they allocate water. And the reason for this is because they have a lot more water than we do over here, and so if there was water on their property, typically they could divert it and use it for what they wanted to. And these are those states east of Texas, except for the Mississippi. And because of the lack of water that we have in the West, we use the prior appropriation doctrine, as Kent alluded to, and it's a system for allocating water where it's first in time, and that means you're first in right. So the person that has the earlier priority water right has the ability to put it to beneficial use before other people can take the water. And this slide is just to represent that, you know, we have far less water than they do in the east. The picture on the right is of the Hudson River, you know, and so that's what they call a river. In the west, this is the Virgin and the Santa Clara, and at times they look like rivers, and that's when they're in their flood stage, but typically when they're in their base flow, it's a pretty low amount of water that they're looking at. So the differences that we have are a difference in climate and geography. In the east, precipitation is relatively abundant, and obviously the water courses are numerous because of that. I'm having some technical difficulty here. Apologize, I can't get my mouse to work. Okay, I'm gonna have to just wing it a little bit here. Okay, so the historical appropriators here in the West were the Native Americans. They were the first that they'd dig ditches and they'd use and divert the water, and so in other words, they appropriate the water here in the arid Southwest. Following them were the religious and military outposts of the Spaniards, and they would sometimes use those same ditches that the Native Americans used to bring water to their outposts and to fulfill their needs. Following them, and the people that really established the prior appropriation doctrine here in the West were the Mormon pioneers. They'd come to these arid valleys, and the water wouldn't be where they needed it to be, and so they'd have to divert it into canals and ditches and bring it to that location where they needed it. Also, part of what established this basic principle of prior appropriation was the California gold rush. And this is shown on this slide here. The miners would come out and they'd stake a claim, and that's where this first in time type of talk started. They would divert the water and use it for their placer claims, and it would be protected in its development against other miners, and so they were the first in right. A fundamental step in deference to state and territorial water law was the Mining Act of 1866, and this came about because of the practices that the miners were doing for their placer claims. And so Congress actually confirmed water rights for mining, agriculture, and other uses that had been acquired by private parties on public lands under local customs, laws, and court decrees. In Section 9 of that act, it says, and be it further enacted that whenever by priority of possession, rights to the use of water for mining, agricultural, manufacturing, or other purposes have vested and accrued, and the same are recognized and acknowledged by the local customs, laws, and the decisions of the courts, the possessors and owners of such vested rights shall be maintained and protected in the same. The first appropriative water rights statute came in 1872, and it was passed in California as sections 1410 through 1422 of the California Civil Code. And there were some requirements. They had to post at the point of diversion that they had a right there. They had to file in the county recorder's office, and they had to perfect the right with due diligence. And this is similar to the process that we use today. And so they had to take those necessary steps to perfect that right with their due diligence. And we still have statute today, just as that last bulleted item states, that the rights that were established could be lost through non-use. Following that was the Desert Land Act of 1877. In the Desert Land Act of 1877, Congress declared that the right to use of water in the United States in the western U.S. by claimants under the Act must depend upon bona fide prior appropriation. The U.S. Supreme Court held that the effect of the Desert Land Act was to sever title of the water from the public land. And Congress directed that the rights to use water be established under state and territorial laws separately from land ownership claims. And so part of what that did for us is that the federal government doesn't come in and administer the water rights within the state. Each state has their own laws, and they're administered through a state process. Wyoming was the first state to have actual statute that gave the state agency a major role. And it required that they file an application, be filed with the state entity, and that there was a ruling on the application by the state agency to say whether they could divert the water or not based on its availability. And they had a maintenance of a central bank of public records. Utah statute wasn't enacted until 1903, and if my memory serves me correctly, Wyoming's was enacted in 1875. And in 1903, the state engineer at that time was Albert Dormus. I don't know if I'm pronouncing his last name right, but he wasn't the first state engineer in Utah, but he was the state engineer when that statute was enacted. In some ways, the traditional appropriation doctrine incorporated public values. A fundamental tenet of prior appropriation law was that land and water estates were separate, and that water could be removed from its natural location and used beneficially elsewhere. This facilitated the public purpose of making an inhabitable region out of the arid West. And so they did give some preference at that time for domestic, municipal, and agricultural needs that had to be met before other water uses could be met. That's not the case today. Everything is based on priority. So it doesn't really matter if you have an irrigation right or a domestic right. The earlier priority gets to divert first. And that leads us right into the prior appropriation doctrine. And as it was enacted in the state of Utah, it contains some key points. First, water must be diverted and put to beneficial use. Second, each water right has its own priority date. And that was to uphold the principle of first in time and is first in right. And as we get into the management of various basins, the priority date becomes of major importance as we administer those rights. And the last point there is that, yeah, you can still lose a right if you perfect it and then you neglect to use it for a period of 7 years or more. It is subject to forfeiture. This slide here demonstrates how water can be distributed by priority date. Those horizontal lines, if you look at the bottom one, it's red, and I don't know if you can see it very well, but it's a priority of 1873. The blue line represents the stream flow in that system, second priority of 1922, and a third priority of 1949 as we track the horizontal lines up. And so you can see that during most of the year, that early priority right does get satisfied. Not all the time, but most of the time. The water right with a 1922 priority gets satisfied less of the time, and that water right with a 1949 priority really only gets satisfied when they're in a flood stage. And so this is how come the priority is important. If you have that 1949 priority, obviously it's of less value than that early 1873 priority. Okay, talk a little bit about the history of the division of water rights. Willard Young was the first state engineer. He's the individual on the left there. And his initial duties were to aid in planning, design, and construction of water storage and conveyance facilities. The job of the state engineer has changed over the years, and it's now to, as I'll read there, he's the individual who's responsible for administering water rights in Utah. He's also the director of the Utah Division of Water Rights, sometimes also referred to as a state engineer's office, and is appointed by the governor for a 4-year term. And it's my understanding that Kent has committed to two more 4-year terms. Was that right? 8 years. Okay. So we got him for 8 years. The Division of Water Rights has become a lot more complex than it was in the beginning. And this slide right here, it kind of gives a false sense of the size of the division, but these are the major parts of the division. So we have the state engineer, and right underneath him is the deputy state engineer, Boyd Clayton. And to the side of the deputy state engineer, you see 4 sections. And these are a little bit different than your notes. I've updated this, but there's field services, and that replaced distribution. Field services is a little more complex than just the distribution of water rights. And on each of those sections, there's an assistant state engineer that manages those with his staff. So we had field services, technical services, and so James Greer, he takes care of studies and other technical things that we need. Applications and records, so if you file a change application or an application to appropriate, it really feeds up through that section. And then dam safety, and they take care of the inspection of dams and the approval of new dams and design and construction, things like that. And they're also in charge of some stream alteration type things. The regional offices, of which I believe there's 7, they fall under Boyd Clayton. He's in charge of those, and so we are really kind of the boots on the ground, and we are each assigned a specific area that we work out of. And this slide right here shows you those areas. So the area I'm in is the southwest area with Washington County, Iron County, Beaver, Millard, that area. But these are called regions. And note the legend in the top right. That tells you where each of the regions are located by color. So Logan's in the light blue, and then you can just trace it down through. Within the regions, there's water right areas. So, for example, the Cedar City, where I'm from, is the 73 basin, and those basins are generally delineated by drainage area, and each one of them typically has a major river system, well, what we call a major river system here in Utah. So, for example, the 81 area, again, down in Washington County, that's the Virgin River, and some smaller tributaries that feed into it. Where there's not a river system, such as the West Desert, they're generally just delineated by the drainage area of that basin. Okay, let's get into some water right basics. So, a couple of important dates for water rights. 1903, legislature passed water laws that required new uses of water to be obtained by filing an application to appropriate with the state engineer. However, it was unclear if the law applied only to surface water, and in some instances, water was considered to belong to property owners. Surface water uses in place prior to 1903 were recognized as valid and are referred to as diligence claims. So, just to sum that up, since the state engineer's office was put together in 1903, any water rights that were used prior to that were recognized. We call those diligence claims. If somebody wanted to come in after 1903 and get more water on a surface source, then they'd have to file an application to appropriate. Now, the next date, 1936, the 1903 law was amended to include all water rights of the state as subject to appropriation statutes. Rights from wells were also recognized as valid and referred to as underground water claims, sort of a sister to diligence claims. And so those would be those underground claims prior to 1936. And so moving forward, 1936 on, if you want to divert water from a well, you had to, again, file an application to appropriate for well water. The rights to use water are not obtained simply because water rights exist on or beneath the property or passes over it. As we talked about before, those would be like riparian rights and are not recognized in Utah law. The legal framework for Utah water right law is found in Title 73 of the Utah Code, and some of the basic and fundamental pieces of the code are here. 73-1-1 declares that all waters in this state, whether above or under the ground, are hereby declared to be the property of the public. Okay. 73-1-3 states that beneficial use shall be the basis, the measure, and the limit of all rights to the use of water in the state. And that's an important principle, and we'll really get into it here in a second. Some of the elements that make up a water right: obviously you have ownership. Somebody has to own that water right. You have a priority date. When was the water right established? A quantity of water, whether it be a flow rate, a volume, or it could be both. Those flow rates are expressed in cubic feet per second. It's a gallon per minute type measurement on a higher level. And volume is measured in acre feet per year. There's a storage element for the water right, or there can be. Not all water rights have a storage element, but there can be. There's a point of diversion, whether it be the well or where they're taking it from the surface source. There's uses of water. Those can be irrigation, domestic, stock water, mining, municipal, etc. There's the amount of use. So if you have irrigation, how many acres are you irrigating? If you have municipal water, how many acre feet of municipal water are you able to divert? There's a period of use. Municipal water be year-round, domestic water year-round. Irrigation, depending on where you're at, it's usually somewhere between March 15th and October 31st, but it can be year-round if you're in the far southwest. And there's a place of use of the water, and that's not necessarily the same place as the point of diversion. You can divert it somewhere and take it somewhere else and use it there. So again, beneficial use is the measure and limit of all water rights. This is an important principle. When buying water rights, you need to make certain that you're bargaining for a suitable right. And so these things that we've kind of touched on already, the point of diversion, source of supply, use of water, diversion, depletion, priority, and ownership. You know, if you're buying a water right that we talked about on that surface source, and you happen to get that late priority right, even though it says you have 40 acres of irrigation, you might only be able to irrigate for a couple months during each of the years. So you have to be careful that you know what the water right is that you're buying. Some other water right details. We've talked about the point of diversion, that we have surface sources, and those can be described as a single location, or they can be described as a point-to-point. Point-to-point is generally a stock watering right, where you can start on a stream at a certain location, and your stock watering are allowed to irrigate, or not, are allowed to drink from there to another point further downstream. Is it a spring? Is there a box there, or a specific location? Or could it be a drain or a well? Another question is the source constant or ephemeral? And I think some of this we kind of touched on already, so I don't need to get into it too far. But uses of water. Is the water right a sole supply or a supplemental right? And I won't get into this too much either, because I think one of the other presenters is going to do that. But just as a quick example, say you have 100 acres of irrigation, and you have 4 water rights together that are used for that irrigation. Well, those will be supplemental rights. And it could be that they're not defined, so you don't know what right A provides or what right D provides. But they could be defined, and so that would mean they have a sole supply. So water right A could irrigate 30 acres, B 20, and et cetera. And so you know exactly what you're getting. And so that's another thing you need to look at when you're purchasing a water right, to make sure you know how much that water right can provide. The next question is, has the water right been constantly used? And that's important, because if it hasn't been used, as we discussed a little bit, for a 7-year period, then it could be it could be subject to forfeiture. Somebody could take you to court and have that water right declared terminated. And what are the diversion and depletion limitations of the water right? We'll get to that in a second here. For priority, surface rights, as we discussed, are frequently regulated by priority. Generally, the priority of a right is the date of filing of the application for an unperfected application or a certificated filing. The priority of a perfected right is the date of first use for a diligence claim, the date shown in a decree, or the date shown on the certificate of appropriation. As far as ownership, if you are purchasing a water right, make certain that the person selling it actually owns what is being sold. Don't simply rely on the division's records for use for this. Excuse me. And if you pull up the division's webpage and you go to a water right, there's a statement at the top that says that we can't guarantee that the data on this page is accurate, and you have to get into the paper documents and make sure that what you are looking at on that page is really what the water right represents. Okay, talking about beneficial use. As stated in statutes, the measure and the limit of every water right. And it's the purpose to which water is diverted under a water right is applied. And I think we've talked about this already too, but some of the examples include irrigation, stock watering, domestic, commercial, industrial, municipal. Okay. Water right flow and volume. Flow, we stated already, is measured in cubic feet per second, and volume is measured in acre feet. And the question comes up, how does this come into play in a water right? So you can have a water right that has a flow limit and an acre foot limit. And so does that mean you get both? Well, it might, but it might not. So for example, if you have a flow, say you have a cubic foot per second, and then the statement says or 100 acre feet, that means you can divert that 100 acre feet at a rate of a cubic foot per second, not to exceed a cubic foot per second, but you have both those limitations. If you were to divert that cubic foot per second for a year's time, you get 724 acre feet. So you can see that you can't divert that the entire time. And so it just plays into the way that you practice irrigating. Just to be clear, an acre foot is a measure of volume. It's an acre of water by 1 foot in depth. And a cubic foot per second, the easiest way for me to see it, a cubic foot is about the size of a basketball. And so however many basketballs you have flowing past a certain point at a certain time is the rate of cubic foot per second. So 10 basketballs, 10 cubic feet per second. If that's helpful. Okay, and one of the other D's of water right is duty, and it's an estimate of the amount of water reasonably required for specific purposes such as irrigation or domestic use. And this map that you can see up on the screen is a map of the duty values for the state of Utah. So most of the state's in green, and so we're 4 acre feet per acre. If you get into the mountainous regions, it typically is 3 acre feet per acre, and down in the very southwest portions of the state, you're looking at 6 acre feet per acre. So it just depends on elevation and what it requires to grow a crop of beef alfalfa. Some of the other duties of water rights for common uses, domestic use requires 0.45 acre feet per residence, unless it's a seasonal or part-time use such as a cabin, and then it would be 0.25 acre foot. Stock watering is 0.02 acre feet per large animal, those being cows or horses typically, and that's equivalent to 25 gallons per day. And we discussed the last point, irrigation typically ranges from 3 to 6 acre feet per acre. Some of the other D's of water rights, I alluded to the D being duty, where we also have diversion and depletion. Diversion is the amount of water that you have a right to divert away from your natural source, whether it's groundwater or surface water, to be applied for the beneficial use. And it can be limited by flow or volume, as discussed. Depletion is the portion of water withdrawn from a surface or groundwater source that is consumed by a particular use and does not return to the natural water source or another body of water. So if you have a domestic use, you see it says 20% there, so it's equal to 0.09 acre feet. That's 20% of 0.45 acre feet, okay? And the reason why it's 20% is because we're assuming that the water flows into a septic system after it leaves the house. So some of the water might be lost, that's that 20%, but 80% of the water we're assuming gets back down into the aquifer. For the livestock units, we assume that 100% of the water is diverted and depleted, so the depletion amount is equal to the diversion amount of 0.028 acre feet. And for irrigation, it's somewhere around 50% depletion, and those numbers are based on flood irrigation. And those vary throughout the state, and we have sources on our website where you can find exactly what the depletion is for whatever region you're working in. Okay. I want to go back to that for a second. Either amount of these can limit a water right. So for example, if you wanted to file a change application on an irrigation right, and you had 10 acre feet and you wanted to use that for livestock watering, well, since livestock watering is 100% depletive and irrigation use is 50% depletive, you would be cut on your diversion amount for livestock. So that 10 acre feet that you were using for irrigation, there was 5 acre feet of depletion. You want to change it over to livestock units, now you have 5 acre feet of diversion and depletion, just 5 acre feet. And so you get a haircut on diversion so that the depletion's not exceeded. Is there any question on that point? Go ahead.
Why is a horse 100% depletion? Have you ever watched one pee?
What's that?
Have you ever watched a horse pee?
Well, it's 100% depleted for me because that's what the Division of Water Rights said.
Can you repeat the question?
Yeah, I can. Yeah, sorry about that. The question was, why is livestock watering 100% depletive? Because there's an assumption that they may return some water to the system. And you probably have a valid point there. That's the number that we use, and I think it's because so very little of the water would get back that how much do you account for it? But we could argue about whether it should be, there should be some that return, but it is a valid question. I don't know that I have a great answer for that. But that's the number that we use in evaluating water rights.
Even though water is passed through the animals, you look at the discharge rate, unless they're standing right in a stream, which occasionally do, they walk in and the people who are getting their camp water just down below where they walk in, you know, they are adding to the stream. But in most cases, when they're out on the range moving around, you look at the amount of fluids that are actually lost to the soil and see where they go. And most of that is lost through evaporative losses. We were going to assign Nate to do a study to go down and have him measure, put little probes in. And follow the cows around, but we haven't worked that into a schedule yet. But that's part of the reason. Even though there is flow through, it's such a minimal impact to where the fluids are lost that we're just considering that 100%. But there are instances where it does return, because I've seen cows walk into water and all of a sudden the flow in the water increases. But for most cases, we just treat that as 100% depleted.
Okay, thanks, Kent. And I'm going to be careful about Kent's involvement in writing up my next contract. Any other questions on that point, or any other point with depletion and diversion? Okay.
When you estimate the water rights for indoor domestic use, very often I have developers asking, the size of this residential unit is a lot smaller than a typical. Can I get a break on that? Is that an average indoor domestic use? Is that completely independent of the land use? Let's say a 3,000 square foot home versus a 2,000 apartment?
It's not. It's an average. So it's 400 gallons per day per unit, and whether you have 5 kids or no kids, it's.
Could you repeat that question?
I apologize. He asked whether the diversion limit for the domestic use was dependent upon the size of the house, the number of people perhaps in the house, or whether it was an average of all those uses across the state. And it's really an average. It's 400 gallons per day per unit. So it doesn't matter if you have numerous people in the house or just one. We use 0.45 acre feet for the ease of management, really is what it is. But when you start talking about municipal use, the water that goes through a municipality is measured. And so it would take into account those smaller uses and those greater uses. These are for people that are really off the grid, and so they're just operating on their own well. It would be 0.45 acre feet, yeah. Okay. Okay, seeing no other questions, I'll move on. Okay, talking about researching water right records for a second here. Where can you research the water right records? We have both electronic files and hard files. Water right files are available via the division's website. So you can go in, you can search a water right number. It will tell you the point of diversion, the place of use, the ownership, all those little details that we went through. However, you do have to be careful because there is that banner at the top that says we can't guarantee that things are exactly accurate. And we're constantly working to update those to try and make it as accurate as possible. But I think we're managing somewhere around 500,000 files throughout the entire division. So there's things out there that just aren't going to get updated right away, but we'll get to them as we come across them. There's also hard files. Well, let me back up for a second. On the electronic files, we also have scanned documents. So you can go in there and pull down a link, and I know we'll go through this later, but it will take you to the scanned documents of the division. And those should represent what the hard file is, but there might be things that are missing in there. The hard files there in the Water Rights Office here in Salt Lake should be the entire document. Okay. I believe all the regional offices maintain a hard file as well, but it's really a redundant copy. So the official copy's up in the Salt Lake office. There's also ways to get notices from the Division of Water Rights for new filings in the past 7 days, new approvals for the past 30 days, proofs due for the next 120 days, and water companies. So you can, there's places that you can subscribe to an email, for example, they'll send you an email if something happens on a water right file so that you'll know that somebody's done something, so that when something gets scanned in, you'll get a notice. Okay, so the division's trying to make it as open as possible so that you can know what's going on. Are there any questions on that point?
What is the process for reporting that information to your office so that you're able to aggregate all that statewide? How does that information come to you? And
Okay, he asked.
help us understand why you put that disclaimer that it may not be accurate.
Okay. He asked how the reporting gets into our electronic files, right? So are you talking about when somebody submits something to the Division of Water Right that pertains to a water right, how do we get that on there?
Well, I'm just trying to understand why you have the disclaimer that, that sometimes the information may not be accurate. If there's a reporting system out there, it would seem that it would be coming in where you would have an accurate.
Right. Well, there's probably a variety of reasons for it, but there's many hands that are in these records. Okay, and so one might make a mistake. So they may input something incorrectly. And so we're saying, even though that's what we put there, that might not be correct. We may not have updated something that was supposed to be updated. So there's always these little things that could happen, but I would say most of it's probably human error. Some of it's just because we haven't gotten into it and updated something yet. Some of these water records are very old, and you'll go into the scanned documents and you'll see that something hasn't happened on this water right for 50 years, and so nobody's touched it for a long time. So there's a lot of reasons why it might not be accurate. Title might not be updated with our office. It might be updated at the recorder's office, but it hasn't been updated with us yet. So, okay. Any other questions? Okay, and this slide's just for my own fun. Can anybody identify this location? There's a hike in Zions called Pine Creek, and it's right at the bottom of the hike, and so there's a great swimming hole there off the highway. If you need to know where it's at, I'll let you know. But the question can be asked, what's the highest beneficial use of water? I'm not sure that it matters because we're a priority-based system. But anyhow, I think for those kids, it's called having fun. Are there any questions or criticisms at our office? That's our department where you can take your criticisms or questions. And if that doesn't satisfy you, I can send you directly to our Human Resources Director.
Question.
Go ahead.
So, because you have the first in time, first in right, is there, if there are two people that applied at the same time, is there a priority of your beneficial uses? Is that listed?
Okay, so she asked about the first in time, first in right, and if two people applied at the same time, is there a priority for their beneficial uses? If they apply at the same time and there's a shortage, then they would be prorated, is what would happen. So if they each applied for 10 acre feet, and they had to take a 50% cut because of what was available, then they'd each get 5 acre feet.
But if there was enough availability?
If there was enough available, then they both get their rights and be satisfied.
Nate, it was interesting in the early years of the filings, they actually had a stamp that showed the time of day when you filed your application, because they're having many applications come in the same day, and they actually put times that they came. So some of the older files you'll look at and you'll see some that was filed at 9:15 in the morning, which would have a priority over somebody filed the same day at 11 o'clock. So they were just so many coming in. It was the time of day that you got in. So I can envision lines at the Division of Water Rights door, waiting to get into the market and get those filed. But but Nate's explained it well. On if it's just the same day, then we do a sharing on that. So.
Okay, thank you. Well, if there's not any other questions, that's the end of my presentation.